Welcome to the We Win Injury Law podcast. I'm Tyler Todd, your host, sitting here with my co-host, Jiren, the Snow Canyon Man Sandberg. Good morning and good afternoon, everybody.
Good morning.
Wait, you're not going to
start? And good afternoon, Tyler.
And good afternoon to you. Boy, what a way to start. It's actually, it's kind of been fun to start with a little good afternoon to everybody. Of course, in a very, nice way. We want to make sure everybody feels our good afternoon.
I thought we were doing it in more of the Will Ferrell way, as intended, good afternoon.
Well, that's what we're doing. Yeah. That's what we're doing. But it's very appropriate that we're doing it even more emphatically today, because we're going to give everybody a little update on the Justin Baldoni, Blake Lively case. There's been kind of some really interesting developments in this case that's kind of happened. And quite honestly, I didn't really see coming, but I saw coming, if that makes sense, and I'll explain myself. But I don't know, the biggest development lately, and if you guys, I feel like it's everything with the internet, right?
Yeah.
We've had clients that will call us and freak out about certain things and certain issues, and I feel like oftentimes the advice has been, calm down, it'll go away tomorrow or in 2 or 3 days. No one will even be talking about it.
Yeah.
Because in today's day and age, it's what's next on the social agenda or the internet, right?
Yeah, news shifts quickly.
I mean, that's been the biggest. I honestly believe with lawyers, we've known for years and years and years that the number one complaint with lawyers is communication.
Yeah.
That has only been, I think, even more, in my opinion, heightened over the last several years because Google, and I believe this, and I've thought about this recently. Tell me what you think. I want to ask you about this. Google and technology has killed, I think, the number one a trait I think that most people need in their lives on a daily basis to survive, right?
Okay.
And I believe that trait is patience, right?
Yeah.
And I believe that technology and Google and whatever platform you use to some degree has killed patience.
Oh, everything kills patience. I mean, even think of how frustrated you get when a new show comes out on Apple TV and they're still doing the old format of not releasing the entire season at once.
Right.
And then even the ones that do, when Netflix releases the whole season, then you're like, oh my gosh, when's the next season coming?
Right.
Everything. I mean, no commercials, skipping commercials. I mean, our whole, everything we do with technology, with media, with entertainment. And I think that's one of the reasons some of these sports have seen downward trends and that no one's talking about is I think that people have lost patience, just like you said. I think that the ability to just kind of sit there and relax and watch. I mean, even you think of something as classic as baseball that, timeless, and now they're doing things to make the game faster.
The pitch clock, all the things. I mean, to be honest, hey, shout out to Savannah Bananas and whatever product you like to call that, right?
Yeah.
With baseball. But yeah, things are changing because our lack of patience is, as that evolves, you have to get faster. So the pitch count in baseball.
Yeah.
And
it upset the purists, but then a lot of people seem to have been like, oh, okay, I like that faster game. And because it's just, gone are the days where you could watch a game go into the 11th, 12th, 13th inning.
Right.
Even putting the runner on second now.
Even our own judges now are telling us, you want a trial that's going to last that long?
Yeah, longer than a day.
People are going to get bored.
People are going to get bored.
Wait, that's what we do. That's the only way we can get justice for our clients. And so,
well, and maybe
when I talk about communication it's just a challenge because, boy, we all, and everyone, and I get it, we expect instantaneous results. So we expect people to wait, and I do it too, right? You didn't see my text?
Yeah.
I sent it 30 seconds ago.
Yeah.
Wait, what? You didn't see my email? It's been in your inbox for all of 8 minutes.
Yeah.
So it's just kind of an interesting thing that the technology, and we need more patience. And I want to emphasize that as we talk about the Blake Lively case, because I didn't anticipate some of these things happening that have happened.
Yeah.
But then on the flip side, now that we've seen kind of what's happened, it's not that surprising as we rewind and look at some of the actions that were taken. So let's get people caught up to speed about what's happened. The biggest one.
Well, the biggest thing that, again, for those that have listened, we kind of mentioned this on a previous show, but, we have, obviously, I mean, how far back do we want to start?
Well, the most recent development has been the dismissal of Baldoni's lawsuit, right?
His countersuit.
His countersuit. It's the $400 million countersuit. And when that was filed, right, it was like, and look, ourselves included, scorched earth against Blake Lively because Baldoni's attorney came out hot, right?
Yeah.
The countersuit, all the stuff on social media. And I think that's what he even used the phrase scorched earth.
Well, and even we've seen posturing before, but then it felt like he almost delivered by filing the countersuit, and they had receipts, so to speak.
Right.
It felt like, oh, okay, this
publishing
has got some
everything.
Yeah. Hey, we're being more transparent than the other side. Here's the real story.
Right.
And we deal with this so much as injury attorneys on stuff where it's like, I have to give our producer a shout out for we do it too.
No, we're doing a bunch of research on the back end.
But I lost my train of thought a little bit, but that's too funny.
No, they come out. Well, he came out. And let me just kind of pick up while you're regaining your thoughts. I want to give the guy a lot of credit because he was publishing everything on, he said he created a separate website. Yeah. He was talking about transparency. They were, obviously the movie, Deadpool 3 or whatever it was with Blake and Ryan and who's the Wolverine guy? Hugh Jackman. Yeah. So you kind of felt like it was the A-list against Baldoni. And I'm not saying like, I still believe Baldoni because I still believe that what they've done and what they have been doing is, I believe they've been bullies.
Yeah.
Okay. And I believe Blake Lively's allegations against Baldoni for a second.
No.
So getting to the legal side of it, I was shocked that Baldoni's lawyer who came out like, oh, and everyone, like I think TikTok, all the comments were like, this guy's amazing.
Yeah.
Right? Was amazing. But to some degree, honestly, how do you get a complaint dismissed? You and I both know that when you file a complaint against somebody, every state has a rule they have rules of civil procedure. Okay. We have federal rules of civil procedure and we have individual state rules of civil procedure. And almost every state's rule 9, I think it is in Utah, and I believe it is for the federal rule. I would imagine that every state's rule of civil procedure, rule 9, deals with pleadings. I'm not sure. I mean, we could Google like Florida or New Mexico.
Seems like Louisiana always has weird stuff on some of
they're
there. So, okay, it's probably
like
7, rule 7
6,
or whatever.
Louisiana, they're weirdo. No, I'm kidding. We just had a great intern that is actually at LSU. So that's...
We can razz them a little.
We can razz them a little bit. But Rule 9 is the rule of the pleading rule in our rules of civil procedure. And what that does is it basically dictates how our complaints, okay, i.e. a lawsuit, have to look. Yeah. So we can't go on fishing expeditions. That's kind of like the common phrase that lawyers like to use when they file a dismissal motion, right? Hey, your complaint is just a fishing expedition, but doesn't actually allege any sort of facts that would give rise to a cause of action.
Yeah.
And a cause of action is what we call like negligence or defamation or assault, right?
And there's some things are a little harder to plead, and some of these like fraud, right, has 11 elements, and every cause of action has so many elements that are hard to prove. They don't require you to have 100% proof. So the standard's not that your complaint has to like lay out your entire trial strategy, but they do have to have at least the minimum facts sufficient that if found true, or a jury were to find them persuasive, then you can move forward.
Right. And you have to plead them with particularity.
Yeah.
Right. You have so you, like you said, you have to have it sufficiently like ferreted out so you're not just on that fishing expedition.
Yeah. And ours, like, so for example, in a common car accident case for me and Tyler, when we're doing negligence, when lawyers, you study this in school, you have to show duty, breach, causation, and damages, but you can't just say that. You can't just say, well, this person that caused the accident had a duty, breached that duty, caused the injuries and damages. You have to actually explain what those mean and what the duty was, how they violated it. It was a rear-end collision. They violated the statute that says following too close. There's a number of things we have to do that at least get you past the sufficient. Now,
And what your damages are. Right.
Now, that doesn't mean we might not find out other things. The person was texting. And so this is where it got weird on this case is normally when you have a sufficiency of the pleading, or at least on maybe a single cause of action that's an issue, sometimes we maybe did stretch it. You normally then seek leave from the court to just amend it. Okay, well, let me add a little bit more in here, or, and there's other times where we find out we get the whole story and we really don't have that particular cause of action. Doesn't mean the whole case gets thrown out, which is why it was weird here that the whole thing.
Well, that's why I say, like, I'm a little shocked.
Yeah.
Because I want to give these teams some credit, obviously, for the way they came out, and it certainly got the court of public opinion on their side.
Yeah.
But yeah, how they would get the countersuit dismissed honestly blows my mind.
Now, we're still within statute of limitations time, I think, on a lot of this stuff where they can refile a countersuit. So that's where it always seems odd that they would dismiss it. Me and you had a case about 10 years ago that was in federal court, and we knew we were making some stretched legal arguments to try to keep the case in Utah instead of Northern California. And for me and you, it was mostly a convenience thing on staying in Utah versus California. And when the judge, in that same case, I don't know if you recall, but we thought they would just transfer venue, and they ended up dismissing the case to then have us have to refile. And there's another filing fee, and I remember at the time thinking,
this is a slip and fall in a shower bathroom.
Yeah. I just remember thinking, like, well, the judge could have transferred venue. That was the easier option, but they didn't. And in this case, I thought, again, I can appreciate the judge's perspective on why there was holes and issues, but I thought we would see this in the form of, like, you have 2 weeks or so long to file an amended notice of amended countersuit and fix the errors. But in here, I think the judge felt like you don't have it.
Well, and that's what's so odd, right? If you're going to come out and basically go scorched earth, right, on Blake Lively and Ryan Reynolds and take that approach, which is kind of what they were representing, and then, of course, all the transparency and posting all the, documents on a separate website, in my opinion, how do you file a countersuit that would be subject to dismissal?
Yeah.
On a Rule 9 type of argument.
Yeah.
That they didn't allege facts with particularity or anything that would give rise to a cause of action. Like, to me, that's crazy legal work or poor legal work.
Now, do you feel like some of this was the judge also saying, because I know there's been quite a few comments that, like, look, a lot of what you were doing felt PR motivated, not legal motivated? Or
Well, yeah. So apparently the judge just a few days ago struck nearly 300-page deposition transcript from the public record. And then basically, in the opinion as to why doing so, felt it was more of like a publicity stunt.
Which is what you never want.
No, because, I mean, look, was there purpose behind a lot of what they were doing to get the court of a public opinion on their side? Of course. And I thought that was good.
I was going to say, I thought if I was going to give them a grade of how I felt like things went social media-wise and even in the general national media, I felt like A
plus, right?
A plus.
Now, to be fair to Baldoni's legal team, I haven't seen the docket. Yeah. So it's very possible that they've already amended their complaint or they've refiled it.
Well, and some of the things they did allow them, there's a few minor things they were allowed to amend and change, but it was the entirety of the really damaging claims got thrown out.
And to be also fair, I don't know, when they were retained, did they file something just quick so they could get it on the docket to show, obviously, the court of the public opinion that they were taking an aggressive approach? Maybe they knew all along that this was going to be dismissed and they didn't have enough facts pled with particularity to survive a motion to dismiss. Maybe.
But it's even interesting because I do feel like, because judges know, so like we get motions to dismiss all the time. I mean, normally it's in the end of the case, which they then kind of convert to, it's called a motion for summary judgment. But
they do that because the defense lawyers like to bill the case as much as they can.
But you don't see it at the first and normally win.
No.
And especially when these are supposedly the best of the best. It's just such a crazy thing to get dismissed. It is
wild. I mean, I was, so that's why I'm saying I was shocked. I didn't think that they would have filed a complaint that would be subject to dismissal with with how important, how big, what a big case, at least on the internet.
Now, can you think of a case, Tyler, in the last 10 years besides the one I pointed out before, which was we're making some stretches on how that reached Utah. Any others that, I feel like I could count on my hand the number of cases we've had dismissed. I don't think any of them have been at the front end.
Well, not dismissed as to Rule 9.
No.
We've
had some summary judgment at the end of the
summary
case
judgment cases
the facts come up to a particular issue, but never.
Yeah, I mean, look, we call our firm is We Win Injury Law. Yeah. We like to win. We do everything we can everything we can do to win. Now, Michael Jordan, it's easy. That's an easy explanation because he's the GOAT, right? Yeah. Tom Brady, arguably the GOAT, but they didn't win every time.
Yeah,
we haven't won every time. We try, but there have been some summary judgment motions we've lost.
But of the lawsuits, and again, just running some statistics here, my assumption is we've probably filed in the last 10 years working together, and you've done it longer, maybe close to 1,000 lawsuits.
Yeah,
and we've had, I think I can count maybe 3. That have been dismissed on summary judgment?
Summary judgment. I can think of, one, because I thought for damn sure we're going to win it. I know that one. I don't know the other two. What are the other two that you're thinking?
One of them was on a medical malpractice, really tricky issue.
Okay, yeah, okay.
So we have one more. Again, I'm not saying it's not a complicated case, but I just think most of the time, and again, these are at the very end of the case when all the facts have come out. And one we knew from day one.
It was going to be a challenge.
We had told the client, look, the judge is either going to decide, and maybe just to give some more context, the whole case from the very beginning, very severe injuries, but the whole case was going to come down to whether our client was labeled as a trespasser or not. And the very first conversation we have with this person is, if we go forward with this, there's a good chance that
we knew that was coming.
A judge could do that, and we need more context. And really, to our client's credit, I think she had assumed more people would come forward and
kind of assist her
with that issue. And really, we just couldn't track down people willing to sit down for deposition. And then her own sister threw her under the bus.
Yeah, that's true. Okay, that was kind of the linchpin. Was kind of the linchpin.
I want to preface that this was a case that when we took on, and again, we don't always have all the facts, but we knew after the sister's deposition that this case was not going to go our way.
Well, yeah, that's a good point. Summary judgment versus motion to dismiss for Rule 9 pleading failure are two different things, right?
Yeah.
A motion for summary judgment is when they're saying, hey, here are all the facts.
Yeah.
These are the facts that we know, and they're not in dispute.
Yeah.
Okay. Based on these facts, the law says you should rule this way.
Yeah.
And that's not what happened in this Baldoni case.
No, this is on the very start.
This is a very hey, the complaint just doesn't really give rise to a cause of action because there's no allegations pled here that really give Baldoni any sort of relief. So that's what's so odd is that it was dismissed in that way so early in the case, prior even to depositions. Now I understand they just deposed Blake Lively. I'm really curious how that went.
Now, this is where I love the power move that Mr. Baldoni himself attended the deposition. That's such because we've had this happen in some cases where the defendant in the case
or
the plaintiff. I like the move. I like the move, and yet when we've had it to ourselves, if it's meant to intimidate the witness, which is what Blake Lively's team tried to say, if that's the intention, then no, it's not a cool move. But it is hard for people, I think, to lie. It's one thing for them to lie to a bunch of lawyers they don't know and they've never met. But when the other person that you're about to
convinced happens all the time.
Yeah, it does happen all the time. But here, when that person's sitting in the room, it adds an extra layer of, can you lie to that person to their face?
Yeah. Well, and he does have every right to be there. I mean, It's his case. He's the plaintiff or he's the defendant. He would have been the plaintiff in his countersuit, but that's no longer on the table, at least that we're aware of. But yeah, I mean, I don't know.
What do you think? Power move? Should we start having our client attend more of when we depose the defendant?
Well, I mean, Lively's team criticized it as some publicity stunt, right?
Yeah.
Or attempting to stage a public event and the whole night, whatever. I didn't see anything on social media about it.
Yeah.
So I don't know what Lively's team is complaining about. Now, I'm not on social media like a lot of other people, so maybe they did see it. Maybe there was a lot of paparazzi there, and I don't know.
Yeah.
Samantha, you know anything about that? Was it a big thing on TikTok or social media that both parties were arriving to the deposition? And so, I mean, it could be like, okay, Lively's team is saying publicity event or public staging, but
now tell me this, do you think that social media is so anti-Lively, pro-Baldoni that if it's not good news to no one cares?
well, it's possible.
Because that might be. I just keep wondering if it had reversed, that Blake Lively had showed up to the deposition of Baldoni, that it might be. Maybe it does become more of a social media.
It is possible.
From a legal perspective, though, do you feel like there's any advantage, disadvantage beyond what I said before, where maybe it's harder to lie to someone when the person's sitting in the room?
Yeah, maybe.
Because
I think if they're gonna lie, they're gonna lie regardless.
Yeah.
Right. And she's an actress.
Yeah.
I mean, so
that's where, again, this is where it goes. If you remember, going back to the Amber Heard, I always that no one considered the optics of how she would look on camera or to the jury, and that they hadn't. Again, you'd think like a trained actress would have done better.
Yeah.
Versus, I felt like Johnny Depp's testimony and even the little quips. Now, some of that's he's probably a little funnier, go to your strengths, but I felt like he knew exactly how to roll little punches. And
he is a good actor.
So, again, not saying that
are we giving Blake Lively too much credit as an actress?
That's what I'm just wondering is there more posturing? Because, again, going back to that Amber Heard, oh my gosh, the internet loved watching Johnny Depp, and they just destroyed her. But there was a lot of things that I felt like, gosh, if I would have been her attorney, I'd have said, don't ignore the person that's questioning you. Don't keep doing these weird. I mean, there was a lot of stuff that I felt like, and again, maybe she's uncoachable because we deal with this too. We try to tell our clients, look, there are certain things you do need to do in your deposition, and the more we tell them what to do, sometimes
I feel like they do the
exact opposite.
Yeah.
And not that we're posturing, but you do want your clients to be very well prepared for what they're gonna hear. But in this case, I just feel like pure power move. I have Baldoni come sit in the room because you already got your countersuit dismissed, and I don't know the sequencing if that happened first or after. But
I don't know. To me, this is my opinion. After the dismissal of the countersuit, I just want to be alone. I want to get to if I'm doing my job. Because the court of public opinion means nothing. I mean, in all reality, it means nothing, right?
Yeah.
Just like Samantha said off camera, I feel like the public's already lost kind of interest. I mean, people are still talking about it, but it wasn't as hot as it was. So let's get to the legal stuff.
Yeah.
Right? Let's focus on the legal stuff. And having Baldoni in the room, to me, screams more of I'm still trying to hold on to this
court of public opinion. I'm not worried about the lawsuit.
Let's do our jobs.
Okay.
And if we're gonna do our jobs, then I don't care about having Baldoni in the room to stare her down. You've already kind of gone through all the things. You better have all your questions ready, and you've already done that with Justin, right?
So
you're not gonna well, what else do we ask? Off camera, or let's take a break. Have I got everything? That doesn't.
You should know.
You should know. So to me, it almost, if I'm Lively's team, I'm really? Okay,
Yeah.
how many more little small victories do we need to have before you start actually doing real legal work?
Yeah.
And I feel like the dismissal, the sealing of the depo transcript, it just seems to me I don't know.
Now, what do you think of this subpoena that went out to Mackenzie Folks, who was a YouTuber with almost no subscribers, that they sent out a subpoena to be deposed?
I think it's interesting. And I say it because, I mean, look, to me, it's a legal team dotting I's and crossing T's, right?
Okay.
Now, to what end and for what purpose were they sending a subpoena to some random YouTuber? Only in the sense that maybe there must be there's got to be some sort of relationship or connection to them. Yeah. But if it was some random YouTuber, that doesn't make sense to me, right? That's what I don't know. I don't know the why or what was the motivating factor behind issuing subpoenas. When we issue subpoenas, we're doing it because there's purpose behind it.
Yeah.
We want to know some information that individual or entity knows that is crucial to, winning our case.
Now, and that's kind of an interesting point too. So like before we file a lawsuit, we don't have that subpoena power. And so me and you kind of make judgment calls sometimes on a big enough case that if we feel like we're not getting information is not being forthcoming on the investigation materials, sometimes we've said, hey, we need to file suit just to get subpoena power.
Right.
And defense attorneys, this is where it's to bill. I'm convinced, at least, is a lot of cases, very typical case. We've told defense, hey, we'll sign a health authorization. You can request any information. We've already supplied them with all of the medical records if they felt like any were missing. And then they turn around and subpoena all of the same records. And it's, I get those subpoenas and it's like 70 pages of legal work. And I'm convinced it's a billing exercise.
It's 1,000% a billing exercise because guess what? They already have most of it. Now, on the flip side, I can see that they're making sure that they have everything because they don't want to rely on us or maybe the opposing counsel, right?
Yeah.
To have sent all the records.
Yeah.
Right. So I can appreciate what they're doing. I feel like it's to some degree a little double-edged sword.
Like when they do it on a $4,000 case or $4,000 in medical bills, I just always think like, how much did you just bill the insurance company?
No, and I think they're crazy. I mean, this happened yesterday in a deposition. This literally happened in a deposition yesterday, where the opposing counsel, insurance defense counsel, says to my client, "Have you gone to the hospital for any injuries, for anything prior to this accident?" Right, trying to find out whether our clients had any sort of pre-existing injuries. Right, that.
A normal question.
A normal good question, right? Because they're entitled to know about pre-existing injuries that, if I have a knee injury prior to this accident and I'm treating for it and then I have an accident and I complain that my knee was injured in the accident, they can bring that up. That's fair.
Yeah, that's fair.
Right? So my client says no to no pre-existing injuries or any sort of hospital visits.
Yeah.
His follow-up question was, well, weren't you born in a hospital? I'm like, wait, time out. Did you just literally try to suggest that my client was being untruthful or dishonest or by bringing up the fact that he didn't mention, oh yes, my previous hospital treatment or visit when I was born 49 years ago, because my client's 49.
Yeah.
And I'm like, are you freaking kidding me? And I'm like, objection. Relevant, foundation. Is there an objection called silly or ridiculous? Because that's what that was.
Well, and now as we prep our clients, we do need to let them know, like, hey, just in case you were born in a hospital, don't forget to bring that up to this particular defense attorney. You don't want to look like a complete fraud by not...
That
you may have, 73 years before been born in a hospital. Now to our older clients who may have been born with and I guess now with the... they did an at-home birth. That would have been even funnier if he was like, actually, I wasn't born in a hospital.
Yeah. But literally, he was like, well, didn't you have a pediatrician? And my client was like, I'm sure I did, but you have to ask my mom, but she's dead. So, and I was like, are you literally going to like continue this line of questioning?
That's hilarious.
It was wild. So look, I'm convinced they do crazy things. And so why issue a subpoena to a random YouTuber? Who knows?
Yeah.
I would hope that there's some kind of connection or familiarity between the YouTuber and maybe Blake Lively or Ryan Reynolds or something, not just some random YouTuber. Because what are they going to do? Subpoena the entire internet?
Now,
who's been talking about this case?
Now, tell me this, on a defamation suit like this, and you might not know, but do you think these celebrities have an insurance policy that's also... Like, do you think some of these... I know. My assumption is that they're paying them out of pocket for everything. But it's another thing when it's the insurance company paying everything out of pocket.
I think.
Do you think they're paying it all out of pocket? Or do you think there's a policy out here that protects them?
Well, Blake and Ryan are the one... Well, Blake's the one that brought the suit.
Yeah.
So it would be Baldoni's potentially a carrier, right, that's paying this other lawyer. I would think they would have coverage, but that's a good question.
Because I think part of the suit, was the production company and some things. So you assume that under the, when they set these up, that there is some insurance. But it does make you wonder, like, If it's coming out of their pockets, I'm mad that you're subpoenaing everyone under the sun.
Well, sure, because I mean that's just
it's one thing when it's your insurance. Like again, I've never deposed a defendant yet in any of our cases that's like cared one way or another what their defense attorney's doing because they work for State Farm.
They don't even know their defense attorneys. They don't even.
I met them this morning. You know, I've heard that before
almost every time. Yes.
So, but in this case, it does make you wonder, like, you know, when they see something like that, or there's, you know, because they seem to be involved in this case, and the judge dismisses stuff. It's like, wait, did I just pay you like $400,000 in legal fees? And
That's right.
We did this big old PR stunt, and you told me I was going to win my case, and you just got dismissed. Like, that's a huge.
It is wild. Well, we're going to see it all comes to an end next year, March of 2026. That's when trials set. So I'm just curious about, you know, what y'all's thoughts are, though. I'm curious to hear about, are any of you concerned about getting subpoenaed? I mean, because there's a lot of you that have been pretty vocal.
Well, and if you listen to the podcast, I mean, maybe we'll get subpoenaed.
Yeah,
we
have a number
on it.
Well, we kind of fall into the category of just random hope with you know, very insignificant number of followers.
Truth. Do you have a connection to Justin Baldoni or Blake Lively? You can admit it.
I wish I had some. I mean, look, Blake Lively I've always been a big fan of hers. Now, again, I think she's on the wrong end of this on this particular lawsuit. I do think she's a better actress than Amber Heard, but not by much.
Okay.
I don't know. And you guys all know how I feel about Ryan Reynolds. He's not that funny. Now, Good Afternoon was funny.
I mean, we quote it almost every show.
Spirited.
I'm going to give that. Will Ferrell probably came up with that.
Yeah, Will Ferrell totally. That was
the writing team. Yeah, you know.
I mean, he's all right. Look, I just don't think he's that funny. But is he a heartthrob? Sure. I mean, say what you want to say about his looks, but anyways. Okay, so March 2026, that's when we're going to really find out how this all comes down. I'm curious also to know whether Baldoni's lawyers will, in fact, amend their complaint or countersuit to see whether they refile that. That's something I'm curious about how the depositions go, because over the next few months, it's going to be pure depositions.
Yeah.
And then if trial is set in March, they have to get a bunch of stuff done before that trial date. So, and then we're going to see whether they resolve it or actually try it. Now, you mentioned the Johnny Depp Amber Heard case. If Baldoni and Blake and Ryan are smart, maybe they just all say, "Look, let's just figure this out."
Yeah.
Do they really want that trial to be it's kind of died? We've talked about that.
Yeah.
I would let sleeping dogs lie, in my opinion, and have it figured out. But who knows what they're going to do? It's interesting. So comment, please. Follow us, find us on TikTok. Comment on some of our videos. I'm curious to see what you guys are thinking in regards to how this is going to go, what they're going to do before March. You think they're going to settle the case? Will it resolve? Do you think they're going to try it? Should they try it? In my opinion, I don't think any of them come out winners.
No,
to be honest. So, to me, I would resolve it.
Yeah,
behind closed doors, get it done.
Confidential settlement, and be done. Let it die.
Let it die. That's my opinion. But, anyways. It's all good stuff. So hopefully we'll have some other updates and talk more about this case. It's been at least fun to talk about at the very least. So check back in, subscribe wherever you listen and watch or whatever you do with your podcasting, and give us a follow, give us a like if you found this somewhat entertaining. And until next time, everybody, good afternoon.